GAL Skills-Based Training. Part 3. Topical Areas Applicable to All Proceedings. Section 1. In Part 3 of your training, we will address topics which apply to all types of proceedings. We will start with litigation and then progress to child development, mental health and substance abuse issues, followed by EPSDT, the Early Periodic Screening, Diagnosis, and Treatment Services. Finally, we will discuss issues surrounding developmental disabilities in education. Each of the training videos in this section contains a small number of topics so that if you need to go back and review them, you can review just one video. In this first video, we will focus on the topic of litigation, which includes developing a theory of the case, using all your litigation tools, using trial advocacy skills, and using caution when dealing with child witnesses. Although the juvenile court system is somewhat informal and much of its successes can be obtained by working with other parties collaboratively, you must remember that at its core, juvenile court is court. Therefore, it is necessary for you to be an expert in litigation skills. Constant case analysis is important due to the complexities, fluctuating factual basis, and potentially subjective nature of child welfare cases. These complexities also can include your own implicit biases. Your first job is to interdependently investigate the facts, and second, develop a theory of the case. In order to develop a comprehensive case theory, you may need to look at many factors from various angles. What is the child's position and permanency goal? What are the grounds for abuse or neglect? Based on the individual child's needs and characteristics, what is needed for his safety and well-being? What is the current state of litigation in the case? What other relevant facts need to be investigated? The first tool you have at your disposal are the discovery rules in the Rules of Juvenile Procedure. These rules allow you to request discovery and also require you to respond to discovery requests. Review these rules often and refer to Part 1 of your handbook. Your second tool is filing motions with the court. The GAL program has a motions bank that can assist you with some of the more basic motions, but it is essential to be comfortable using the litigation tool outside of the motions bank. For example, if you have requested a service be provided to your client and it wasn't approved by DFS, you can motion the court to order that service be provided. Some typical possible motions include motion for visitation, motion to change the permanency plan, motion for provision of services, motion for access to confidential records, and motion to compel. It is your job to make sure your client's case is handled in a timely manner. Be sure to file motions requesting hearings when necessary as well. Do not abuse it, but if it is necessary for your client's success and in his best interests, use this valuable litigation tool. You must be familiar with jury trials, as any party can request a jury in juvenile court, including you if you think it is necessary for the case. Understanding the differences in litigation skills from a bench trial to a jury trial is essential. Experience with voir dire, jury selection, and persuasion of juries is important, especially since the number of trials in Wyoming's juvenile courts are increasing. Be aware that there are model jury instructions for juvenile court and examples of instructions in termination of parental rights proceedings which are available for you to use. If you need an expert to zealously advocate for your client, request one from the program. There are funds available for this litigation tool. If the expert is providing a service or treatment for the client, this is paid for by DFS. But if the expert is used to prove an element or part of your case at trial or at hearing, it is a litigation tool, and it is appropriate to request through the GAL program. If the request is reasonable, necessary, and there are funds available, it will be approved. Be aware of your ethical duties to provide an expert that is reasonably necessary in the case. For more information on this, refer to John Berman's book, Justice for Children. When using an expert, be sure he possesses sufficient knowledge, skill, experience, training, and education in order to qualify. Be sure to develop your basis for opinion on a broad range of facts and data prior to presenting the expert's opinion. Remember that trials are stories, and they should be persuasive to the judge or the jury. Take time to prepare your story, including the theory, theme, and frame. Zealous and effective trial advocacy is an art that is developed over time. There are trainings and resources available to help you develop this skill. The most applicable assistance is a book written by Marvin Ventrell titled Trial Advocacy for the Child Welfare Lawyer, Telling the Story of the Family. Topics covered in Mr. Ventrell's book range from case analysis and openings and closings to direct and cross-examinations, exhibits, telling the story, making and meeting objections, to dealing with difficult witnesses and integrity in the courtroom. Use caution with child witnesses. In order to know when to question reports of child testimony or interviewing, and when to seek an expert's review, you should be familiar with the suggestibility literature that revolves around age, questioning by authority figures, the effects that interviews have on children, and details and participants. There are basic competency issues to consider for children who testify in court. The child must have a certain level of intelligence, the capacity to observe, adequate memory, and the ability to communicate. He must also be aware of the difference between truth and a lie, and he must understand the need to tell the truth in court. There is research into the effects on children testifying in court. This is something often raised by attorneys, yet no agreement has been reached as to whether the effect of testimony is positive or negative. It is important that you consult with mental health professionals in making this decision for your client. You should also ensure that the child has support and is prepared to testify. This may mean taking him to the courtroom when it's empty to let him see it, showing him where certain people will sit, and allowing him to sit in the witness stand. This will usually ease some concerns for the child. Hearsay exceptions can be especially important for a child's out-of-court statements because they are often powerful evidence of abuse or neglect, and some children are ineffective witnesses or they cannot take the stand at all. There are a number of exceptions that could be used to allow evidence to be presented, such as prior consistent or inconsistent statements, charge of fabrication, impeachment, present sense impressions, excited utterances, fresh complaint of rape or sexual abuse, diagnosis or treatment exception, and residual and child hearsay exceptions. There may be a time when you need to provide syndrome evidence during a trial. Syndrome evidence is considered either diagnostic or non-diagnostic. When it is not possible to reason backward from symptoms to cause, the syndrome lacks diagnostic value and is therefore non-diagnostic. Nearly all psychological syndromes are non-diagnostic. When a new syndrome or a syndrome of questionable reliability comes up, a Frye or Daubert hearing should be used to test the validity and reliability of the syndrome. This is important for you to know if you are going into an adjudicatory hearing or permanency hearing that is contested and syndrome evidence is being used. You'll want to know what is reliable and what is not. There are several types of syndromes that often come up in child welfare cases. Battered child syndrome, usually found in children under the age of 3, is often cited. This is not novel scientific evidence and is therefore not subject to Frye or Daubert. Battering parent syndrome is another syndrome cited. Courts usually reject this evidence. Munchausen syndrome by proxy is not subject to analysis under Frye or Daubert, as courts have upheld its validity. Also, shaken baby syndrome has been accepted as a valid medical diagnosis, therefore it is not subject to Frye or Daubert. A diagnosis of post-traumatic stress disorder does not necessarily prove trauma. There is little probative value to provide substantive evidence of trauma. Child sexual abuse accommodation syndrome should not be used as substantive evidence, although it is admissible to rehabilitate a child's credibility following impeachment when it is focused on delayed reporting, inconsistency, or recantation. Parental alienation syndrome, or PAS, is considered non-diagnostic. Any use of PAS for diagnostic purposes may be a misuse of the syndrome and may not pass muster under Frye or Daubert. It has also been criticized as the American Psychiatric Association said there is no data to support this syndrome. These litigation tools and skills will prove invaluable in zealously representing your child in court. Continue to use and hone them for the benefit of the children you have the privilege of serving.